There's a hold up at both the front and the back of court. There's a giant queue which goes halfway down the road, and that led to some of the papers apparently being late into court. Although I think all the personnel got here just in the nick of time. There were papers that were still arriving, so I'm very sorry about that.
Okay, right. Next preliminary point to say is that this court yesterday was extremely cold. We don't want to cause. I can see Miss Smythe already rubbing her hands, but maybe she's not here. So maybe looking forward to the argument. Please let us know if there are difficulties, and we'll try and do something about it. Right. Do you want to introduce everybody first of all, and then I've got another point I want to make.
Thank you, my lord. I appear with Mr. Lee and Miss Asanovich for the appellant. Miss Smythe, King's Counsel, Miss Jackson and Miss Wakeman appear for the Secretary of State. Mr. Bewley, to my right, King's Counsel, and Mr. Shattuck are here for the Air Centre.
Yes.
Mr. Rogers, in the middle, King's Counsel, is for the IMA. Mr. Cox and Miss Radford are in the Molnar appeal. They're the appellants in the Molnar.
Sorry, I should say it's Miss Jackson and Miss Hyde for the Secretary of State. Miss Wakeman appears on the papers.
Yes. Well, Mr. de la Mare appears on the papers, but it doesn't seem to be here today.
No, he's in a long trial, I'm afraid, so I've had to take over.
Right. Thank you very much, Mr. Hickman. Now, next point is, have you had a chance to discuss how you're going to divide the 2 days we have?
Yes. So I'm proposing to go first, and I will take up this morning and run potentially a bit into this afternoon. Then Mr. Bewley, who has leave to appeal in the Vargova appeal, will go next because he doesn't have permission to appeal in Molnar. He's intervening.
Yes.
Yes. Then we've agreed that Mr. Rogers will go next with his 45 minutes. And then finally, Mr. Cox will.
So Mr. Bewley's going to be how long?
Half an hour, my lord.
Half an hour. Mr. Rogers.
45 minutes.
And then Mr. Cox. Yes. How long is Mr. Cox? How do you think?
I expect, my lord, 30 minutes. I'll be adopting Mr. Hickman's submissions, and I'll be.
So does that mean we're going to finish your side of the argument, as it were, today?
I think there's a chance we might slip a little into tomorrow morning, and I have discussed that with my own friend, and she's comfortable with that. She would like 4 hours, and I think we can accommodate that. We'll see how we go. But we're all fairly comfortable, I think, that we can make it work.
My lord, that's right. Certainly no more than slipping into tomorrow, I would say. I should say that the Secretary of State was concerned that 2 days was very tight, but the other parties resisted us having more time, so we were keen that the Secretary of State's time shouldn't be compressed.
No. Well, I think we're going to keep you very firmly to that time, those times, Mr. Hickman. Thank you very much. Now, we've read, obviously, the skeleton arguments from the judgments and the withdrawal agreement. We haven't necessarily, for my part, necessarily looked at all the authorities bundle, but we think we're on top of the issues.
Very good, my lord. Can I explain the way I propose to
deal
with it? So first of all, I'll just relatively shortly give you the procedural history in relation to my client, Vargova. Then what I'd like to do is go through the legal materials to introduce them and highlight the bits that are going to feature most significantly in the submissions, but without, as it were, making my submissions on them. Then I'm going to deal with ground 2, which is the issue about citizens' rights directive proportionality.
Yeah.
I prefer not to call it proportionality because proportionality has a particular contextual specific meaning in relation to the Citizens' Rights Directive. So CRD proportionality, that's ground 2. So I'm going to deal with that first, and then I'll deal with ground 1 when I've completed my submissions on ground 2.
Would it help us just to look, if I may, Mr. Hickman, at the key parts of the withdrawal agreement first?
Yes.
Would you mind if we did that?
I would not mind if...
Article 20 and 21.
Yes. So we're in tab 17 of the
Oh,
British bundle, page 144.
yes.
I'm sorry, that's Article 13, we're on page 150. So, Article 20.1, conduct of Union citizens or United Kingdom nationals or family members, other persons who exercise rights under this title, where that conduct occurred before the end of the transition period, shall be considered in accordance with Chapter 6. So,
Yes.
that I think is fairly straightforward. You look to Chapter 6
Yes.
and you apply it. We're not within that paragraph because Ms. Vargova's crime was committed.
Neither appellant is in that category.
My lord, yes. So we then look to point 2, the conduct of Union citizens and so forth who exercise their rights under this title, where that conduct occurred after the end of the transition period, may constitute grounds for restricting the right of residence by the host state or the right of entry in the state of work in accordance with national legislation. That makes clear that there can only be a restriction on the rights exercised under this title on the basis of conduct. Okay? So it's got to be conduct, but that conduct, the grounds relating to that conduct can be based on national legislation. That's subject to Article 21 underneath,
Yes.
which applies the safeguards in Chapter 6 and Article 15 in relation to any decision that restricts residence rights of the persons referred to in Article 10. Now, what we have before us are two grounds. The ground 1 is whether a decision to make a deportation order against my clients under the 2007 Borders Act, which is a form of automatic or mandatory deportation, restricts her residence rights. That's ground 1.
Yeah.
Point that arises on the interpretation of Article 21. And ground 2 is whether the safeguards set out in Article 15 and Chapter 6 import what I call CRD proportionality. And that second point is of very wide importance because on the Secretary of State's case, the only protections that are imported by Article 15 and Article 6, as we understand it, are essentially notification of the grounds on which you're going to be deported and an appeal right. And that would mean that national legislatures in any EU country or in this country could set out grounds for deporting people with exercising withdrawal agreement residence rights, including permanent residence rights, on any basis at all, as long as it's related to conduct. It could be the most minor infraction, doesn't even have to be criminal, without any control, and that their only withdrawal agreement rights would be to be told why they're being deported, or subject to another restriction, have to be deportation, on their residence rights, and have an appeal. And it would permit the sort of thing we get under the UK Borders Act, but potentially in relation to other types of conduct. It's 1 year imprisonment under the UK Borders Act, but it could be something much more minor, where essentially you've got a whole category of people that are simply automatically told, well, anyone in that category. So you'll get a notification, you fall into that category, you've done something minor by way of conduct, you're within a very broad category, and you have an appeal, but of course the appeal would be largely empty unless you could show some mistake about you being in that category. So there'd be almost no control. Withdrawal agreement would be, we would say, largely empty in terms of the rights that it confers on people exercising residence rights under the withdrawal agreement. So we say it is of great importance, the question about whether or not the safeguards imported by Article 21 include a principle of proportionality. In our submission they do, and as I'll explain, there is authority
Thank you.
to that effect.
That's very helpful. Now, you wanted to go first to the procedural history so far as your client is concerned. Did you?
My lord, if I may. And I'm just going to go through it very, very quickly and briefly because nothing greatly turns on it, but just so that you've got the lay of the land, as it were. Ms. Vargova's deportation was deemed to be conducive to the public good under Section 5 of the Immigration Act by operation of Section 3.5 of the Borders Act 2007, because she was subject to a term of imprisonment of over 1 year in duration. She received notice of decision on the 12th of December 2022, which is in the bundle. I just want to briefly show it to you because I want to make some points on it later, at page 198.
Of your core bundle?
This is the core, yes, the core bundle in my case. I won't be referring to the bundle.
198.
Yes, it's at the back of the binder tab. So what you have to begin with is a letter to the prison governor, and it encloses a document entitled Notice of Decision to Deport. And under Part 1 you see there is a reference to the conviction and the sentence, and then at the end of the first paragraph, and a point that I will make by reference to this later, so just to flag it to you now so we have it, you have not shown that any of the exceptions apply to you. As you'll see, there's exceptions in the 2007 Board.
Yes.
None of the exceptions apply to you. If you look over the page, there's rights of appeal. So under it says Part 3, next steps, right of appeal. A person with EU status leave, there is a right to appeal against the deportation decision under Regulation 6 of the Citizens' Rights Appeals Regulation 2020. You have 14 days to appeal, and it says you can now appeal on the basis that the decision breaches any rights you have under the withdrawal agreement, or the decision is not in accordance with the Immigration Act. She's also informed that if she has human rights points to raise, she can raise them at this stage, and that's under the heading One Stop Notice, page 202. And in particular, if you look at page 203, first full paragraph, you may raise any human rights issues at this stage, and we will consider these. If we do not accept that you should not be deported on human rights grounds, you will have a separate appeal against this decision. That's a Section 82 appeal from a human rights decision. And then the fourth paragraph down the page, if you do not wish to inform us about any reasons why you think you should not be deported from the United Kingdom, a deportation order will be made against you and arrangements made to deport you from the United Kingdom at the earliest opportunity. So in other words, if subject to any appeal that might be made under the 2002 Citizens' Rights Appeals Regulations for breach of the withdrawal agreement, if Vargova did not wish to make, or the person in her position did not wish to make any human rights arguments, or rely on any other exception, then they will be subject to a deportation order.
And it's your case, is it, that this letter restricts rights of residence?
It's not the letter; it's the decision.
The decision.
Yes. And again, there's also authority on that, which I'll show you in due course. Ms. Vargova exercised her right of appeal, and on the 8th of September 2023, Judge Anthony in the first tier tribunal allowed the appeal on the basis that the decision and deportation consequent on it would be disproportionate. And if you take up tab 19, page 183, we have the decision. And at paragraph 6, the judge states that they find the appellant enjoys the procedural protections set out in Article 21 of the Withdrawal Agreement, which we've just looked at. Then quotes Article 21. It says Article 21 imports the whole of Chapter 6. This includes Articles 27 and Article 28.1 of Citizens' Rights Directive, which are preserved for the purposes of procedural protections. So the emphasis very much on the procedural protections, as well as their justification proportionality requirements. And there's then a reference to Article 21, and the judge goes through the facts, and the conclusion is at paragraph 15, having weighed up all the competing arguments, and having applied Article 15 of the Withdrawal Agreement, Articles 27.2 and Article 28 of the Citizens' Rights Directive, they reached the conclusion that the appellant's previous criminal convictions cannot in and of itself constitute grounds for the respondent's expulsion decision. I place weight on the fact that it represents a low risk of reoffending, low risk of harm to the public. I find it's an important consideration that tips the expulsion measure into disproportionate emphasis on the appellant's past offending. I've also balanced all of these considerations against long-term free movement rights exercised for over 13 years. Therefore, having applied the safeguards set out in the Withdrawal Agreement, having applied the EU principle of proportionality, I reached the conclusion that the expulsion decision by the respondent is a disproportionate measure. So it's very clear that the central point on which the appeal is allowed is that it's disproportionate, having regard to the individual circumstances of my client. The Secretary of State was granted permission to appeal, and the appeal was allowed by the Upper Tribunal on the 26th of September 2024. The President and Upper Tribunal Judge Hanson. We will look at their judgment in detail. I don't want to go through it now because I will need to make a number of submissions on it. But they reasoned, in essence, that Article 21 imports only what we might regard in common law terms as classic procedural protections, notice and comment, notice and a right to representations, and not proportionality. And that was a fundamental mistake that the judge in the first tier tribunal made. They also said that in any event, the decision was not a restriction on the rights of Ms. Vargova, and therefore there could be no breach of Article 20.2 and 21. Prior to the Upper Tribunal's decision, Ms. Vargova had made a human rights submission. These were rejected, and a deportation order was made on the 16th of February 2024. And that's in the second bundle. We don't need to turn this up.
And that's the subject of a further proceedings, isn't it?
Yes, that is.
Yes.
So turning then to the legal materials, and then I'll turn to my submissions. Can we take up the authorities bundle and begin with the, as it were, beginning with the Immigration Act? I'm going to, if I may, start with the domestic materials, partly because I'm going to take things broadly from the order. So the Immigration Act is in tab 2, and section 3(1). Person may be given, this is 3(1)(b), he may be given leave to enter the United Kingdom, or when already there, leave to remain in the United Kingdom, either for a limited or for an indefinite period. And then we can jump down to section 5. Person who is not a British citizen is liable to deportation from the United Kingdom if A, the Secretary of State deems his deportation to be conducive to the public good, or another person to whose family he belongs is or has been ordered to be deported. So that's, as it were, the standard ordinary deportation provision that's subject to the 2007 Act, which we'll look at in just a minute. We then have 5A, which was introduced in 2020 by the EU Withdrawal Act 2020. The Secretary of State may not deem a relevant person's deportation to be conducive to the public good under subsection 5 if the person's deportation would be in breach of the obligations of the United Kingdom under Article 20 of the EU Withdrawal Agreement, and so forth. And then subsection 6, without prejudice to the operation of subsection 5, a person who is not a British citizen shall not be liable to deportation from the United Kingdom if, after he has attained the age of 70, he is convicted of an offence for which he is punishable with imprisonment, and on his conviction is recommended for deportation by a court. So there's a further provision in relation to judicial recommendations, which I'm sure you're familiar with, and that will crop up in one of the authorities that I will show you. And then 6A, which was another provision inserted by the 2020 Act. A court may not recommend under subsection 6 the relevant person be deported if the offence for which the person is convicted consisted of or included conduct that took place before IP completion day. And then can I just show you Schedule 3 to the Act, which set out in particular provision for detention pending deportation. That's at page 36. So there's a heading under paragraph 1 of Schedule 3, detention or control pending deportation. So first of all, paragraph 2 deals with where there's a recommendation for deportation by a court, and where that is in force in respect of any person, the person is not already detained in pursuance to a sentence, then he shall be detained pending the making of the deportation order. And then at subparagraph 2, so 2.2 as it were, where notice has been given to a person in accordance with regulations under section 105 of the 2002 notice of decision provisions, of a decision to make the deportation order against him. So it's a decision to make the deportation order, not deportation order, I emphasise, which triggers this power, and he's not detained already. He may be detained under the authority of the Secretary of State pending the making of the deportation order. So there's a general power that allows the Secretary of State to deport people once they've decided to make a deportation order. detain people. Absolutely making, yeah. So that's overlaid by the UK Borders Act 2007, which we'll take next, which is at page 78, tab 8. This makes provision for what's termed automatic deportation. And there are two conditions for automatic deportation. It applies, as you see, from 32.1 to a foreign criminal, foreign national criminal, more colloquially referred to, not a British citizen, a person who's been convicted of offence and to whom condition 1 or 2 applies. And the condition 1 is that the person is sentenced to a period of imprisonment of at least 12 months. And that condition applies to my client. Section 32.4 then says, for the purposes of Section 3.5a of the Immigration Act, which we've just looked at, the deportation of a foreign criminal is conducive to the public good. So there is as it were, a form of deeming provision. 32.4. And then 32.5, the Secretary of State must make a deportation order in respect of a foreign criminal subject to Section 33. So there is a mandatory requirement to make a deportation order. None of this is discretionary. The conditions set out in subsections 1, 2 and 3 don't include any element of discretion, and if you're within those provisions, then your deportation is deemed conducive, and a deportation must be made subject to Section 33.
And the exceptions therein?
The exceptions there are over the page. So Section 33, Section 32, 4 and 5 do not apply where an exception to this section applies, subject to subsection 7, and then there's a series of exceptions. We don't need to look really in detail at all of them, but exception 1 is where removal pursuant to a deportation order would breach convention rights or refugee convention rights. Exception 7 at 6b over the page is where the foreign criminal is a relevant person and the offence for which the foreign criminal was convicted, as mentioned in 32.1b, consisted of or included conduct that took place before IP completion date. And the purpose of that, you will appreciate, is to ensure compatibility with Article 20.1 of the Withdrawal Agreement, because where conduct relates to pre-IP completion date conduct, you can only be deported in accordance with Chapter 6 of the CRD, and automatic deportation of this nature is not consistent with Chapter 6 of the CRD. And then at subsection 7, the application of an exception A does not prevent the making of the deportation order, and B results in it being assumed neither that deportation of the person concerned is conducive to the public good, nor that it is not conducive to the public good. And I think that is, the purpose of that is to allow, as it were, an individualised deportation order to be made. So although this automatic regime wouldn't apply, the Secretary of State could still make a normal, as it were,
conducive to the public good
deportation order. So that's the purpose of that. We will need to come back to that in due course. But the other point to note about these exceptions is there is no exception that applies to any other breach of the withdrawal agreement,
including the one that your client is covered by. That's your point.
My client, yes, has to appeal under the 2020 regs on the basis that there's a breach of the withdrawal agreement. we will need to look at some of these provisions again, but can I just flag one, which is the detention provision at 36. So we've already seen the general detention power in Schedule 3
Yes.
of the Immigration Act, but there's an overlay, the sort of theme of this piece of legislation, which overlays the deportation regime, which provides an additional ability to detain. Section 36(1), a person who served a period of
Sorry, of what?
a person.
Of the same act.
Yes,
Sorry.
yes, my lord.
Carry on.
It's at page 82,
Thank you.
section 36. A person who served a period of imprisonment may be detained under the authority of the Secretary of State while the Secretary of State considers whether 32(5) applies, and where the Secretary of State thinks that 32(5) applies, pending the making of the deportation order. So, my lord, can we now look at the EU Withdrawal Agreement Act briefly? This is at page 118 of the, I know I'm going to look at this before, as it were, we go back to the Withdrawal Agreement, but I think we can take this relatively quickly. The Withdrawal Agreement Act is at page 118, tab 15. This was to give effect to the withdrawal agreement, and you can, just to make the points I've made to you, you can see that it inserts 5A, 6A, and so forth into the Immigration Act, and over the page you can see that it inserts exception 7 into the 2007 Act.
Yes.
And then if you turn over the page at 121, there's a power for a Minister of the Crown to make by regulations provision for in connection with appeals against citizens' rights immigration decisions of a kind described in regulations. And for the purposes of that section, subsection 2, each of the following is a citizens' rights immigration decision, and that includes at F, a decision to make or a refusal to revoke a deportation order under Section 5 of the Immigration Act in relation to a relevant person. And G, any other decision made in connection with restricting the rights of a relevant person. So there's a power to make regulations to appeal from decisions restricting rights, and it expressly includes within that a decision to make a deportation order under Section 5(1) of the Immigration Act.
Is the phrase citizens' rights immigration decisions defined?
Subsection 2.
That's the definition.
Yes,
So that's all those decisions
yes,
are a citizens' rights immigration decision.
that's right. Within the meaning of the legislation.
Right, so I follow. Thank you.
So then let's look at the regulations briefly, which have been. Actually, no, I just want to show you that very briefly the explanatory note, page 134, which accompanied that. It's the next tab. And can I just ask you to read para 157 and 158 of the explanatory note to the Act. We've just been looking at the 2020 Act on page 134. particularly 157. So that the way it works then is you have a right for judicial redress, right to judicial redress under Articles 18 and 9 and 21, the Withdrawal Agreement, for where there's a restriction on your rights, Withdrawal Agreement rights. The legislation is intended to give you that judicial redress, and then under the legislation we have the regulations which have been made, which are page 159 of the bundle at tab 18, the exiting the European Union, so the Immigration Citizens' Rights Appeals EU exit regulations, which I'll probably just refer to as the 2020 regulations. And you can see from that page that it's made under section 11, we've just looked at, and then in particular we're interested in regulation 6, which is at page 163, the right of appeal against decisions to make a deportation order, express right of appeal in relation to deportation order. I've shown you the basis for that in section 11. And that's 6.1, a person to whom paragraph 2 applies may appeal against the decision made on or after exit day to make a deportation order under section 5 of the 1971 Act in respect of them. And then it refers to the various categories of person, which we don't need to worry about because we're common ground within those categories. And you get the grounds of appeal at regulation 8, which is at page 167. And an appeal under these regulations, I'm reading from regulation 8.1, must be brought on one or both of the following two grounds. And then at 2, the first ground of appeal is that the decision breaches any right which the appellant has by virtue of, and then little a includes part 2 of the withdrawal agreement. So there's an express right.
Sorry.
So it doesn't include the whole. I'm having difficulty reading this. It doesn't include the whole of part 2, does it?
Right. Just make sure I'm in the right place. We're on regulation 8, yes?
Yes.
Okay. Just say what you said again, would you?
Sorry. So regulation 8, an appeal under these regulations must be brought on one of the following grounds, and the first ground is that it breaches a right under certain provisions of the withdrawal agreement, and that does include Article 2021. It's chapter 1.
Because it's chapter 1. Thank you.
Sorry.
1 is 13 to 20.
Yeah, 13. That's right. I'm sorry. Chapter 1.
Chapter 1 includes Article 21.
Yes, it does. Yeah. There's no dispute about it. So that's the basis for the appeal. Then can we go to the withdrawal agreement? Back to the withdrawal agreement. So this is at tab 17. And what I want to do before making my submissions on ground 2 is just to look, as it were, the umbrella provisions that apply to the whole of the withdrawal agreement. And those in Article 4 and they've recently been subject of a ruling of this court. So once we've looked at these, I'll take you to that and just show you the propositions that one can derive from the ruling of this court. And that's in the case of AT. But you will see, first of all, Article 4.1, the provisions of this agreement and provisions of union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member states. And it then goes on, the second part of sub-paragraph 1 to refer to the need for directly effective rights, which of course the withdrawal agreement has. But there are two self-standing limbs there. The core principle is set out in the first sentence, and it is the principle of equivalent effect. So the agreement has to have equivalent effects in the United Kingdom and throughout the EU.
Yes.
4.2, the United Kingdom shall ensure compliance, including as requiring or permitting judicial and administrative authorities to disapply inconsistent and incompatible domestic legislation. Point 3, the provisions of this Act referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. So there is a requirement to identify where this agreement is referring to union law or concepts. And one of them, I will say, is the concept of procedural safeguards or provisions of union law. And they shall be interpreted and applied in accordance with the methods and general principles of union law. Point 4, the provisions of this agreement referring to union law...
Includes case law before the transition period. Includes case law.
It certainly does, yes.
Yeah.
Provisions of union law or concept provision shall be implemented and application to be interpreted in conformity with the relevant case law. So it's not just applying union law, but it's applying concepts in accordance with the case law. Very clear a distinction between union law or concepts or provisions thereof must be applied in accordance with the case law of the CJU. And then there's a requirement.
What does that? So what does that add? What does concept add to provisions?
Well, the key point for us is that Article 21, for instance, clearly incorporates provisions of European Union law because it incorporates provisions of the CRD. And where the CJU has interpreted relevant provisions of the CRD, that's binding on you because it's union law.
Yes.
But where a concept is, as it were, lifted from the CRD and used in the withdrawal agreement, okay, so it's borrowed concept.
Lifted or borrowed.
It's still binding, yeah. The interpretation of that concept by the CJU is still binding. That's the distinction, I think, that it's drawing.
You referred there specifically to procedural safeguards
Yes.
as a concept,
Yes.
but presumably you also rely on proportionality
Yes.
as a concept.
Definitely.
Relevant concept. In the union law sense,
Yes.
rather than ECHR.
So it's yes. So can we just turn to AT and see how these provisions were interpreted by this court in that case? The judgment of Lord Justice Green, with which Lord Justice Dingmans and Lady Justice King agreed, it's at tab 40.
The back of the first bundle.
Yeah, it's not the very bad. I've got 41 tabs, but you may have 40 tabs. It's 673 tab 40. So this was a case about a claimant who was a Romanian national and lived in the United Kingdom, had been granted pre-settled status under the EU settlement scheme. After the transition period had ended, the claimant and her daughter left the home that they were sharing with the claimant's partner because of domestic violence, and went to a refuge run by a charity. I'm just at the moment looking at the head note on page 673. The claimant subsequently claimed for universal credit, and this was refused. And the issue in this case was whether the refusal of universal credit, which left the claimant destitute, was contrary to the withdrawal agreement, because it left her in a situation of destitution which breached Article 1 of the Charter of Fundamental Rights.
I'm so sorry, Mr. Hickman. I don't seem to have this authority in either of the bundles of authorities.
Oh dear.
Has anyone got a spare copy?
673.
673, yeah. 672.
No.
So it ends with.
I can work
Do you
on
not-
mine if you want.
Milo, do you not have two bundles of authorities?
Yeah, I've got two, but
Someone's been
My
taking
bundle-
out.
Someone's taken out your main authority, Mr. Hicks.
My
Miss
bundle-
my.
my bundle 2 starts with.
That's a low
tab
blow,
41,
Mr.
and I haven't got a tab 40 for some reason.
I'm very sorry. We've got a spare.
Would one council bear to?
Yeah.
Thank you so much.
For the non-mark. We haven't.
I'm sorry about that.
Well, it's not.
What you gather from that is that I haven't read it before the hearing. Because I'd have noticed.
Well, you might have.
That's very kind. Thank you very much indeed.
Right. So you were telling us about the history of the claimant in this case.
So the claimant in this case has a right to reside under the withdrawal agreement.
Yeah, was refused universal credit, which left her, your phrase, destitute. And the argument was this was in breach of Article 1 of the Charter.
Yeah, because the refusal of universal credit represented an interference with her right to freely reside.
Under Article 21.
Because you have to read Article 13, which confers the right to reside consistently with the underlying Article 21, which brings in the Charter as essentially a general principle of EU law.
Yep.
And perhaps I could just ask you with the first point of the head note over the page on the holding, which I think gives you most of what.
Would you like us to read that?
Yeah, just the first
Okay.
point. In fact, could you read both parts? I'm sorry, that's a large chunk of text, but would you mind
Okay.
just reading?
Yes. You want to sit down, Mr. Hickman, while we do that? You want to sit down?
I'll stay standing.
Okay.
That's all right, Milo. Thank you. Never make it up again.
So my eyes have highlighted on the words individualised assessment.
Mine, yes.
Would that be what you want me to?
Well,
Look at in particular?
I'm going to need to come to this judgment for several points. But I think if you've got a sense of what the judgment decides, then I can highlight the points that I want to emphasise. And to begin with, what I want.
Well, that's your point, isn't it? The proportionality involves an individualised assessment of each claimant.
It does.
That's your case, really, in a nutshell.
It is.
Yes.
But can I just show you the way Lord Justice Green deals with the Article 4 of the Withdrawal Agreement, and we can pick that up in a way. Paragraph 49, 699, where he's dealing in general terms with the Withdrawal Agreement. I just want to flag what he says because he refers back to it in the second sentence of paragraph 49. It's perhaps a statement of the obvious, that the agreement reflected the end result of difficult and complex negotiations, and its final terms embodied compromise or overall balance, and it is diplomatically expressed in the recitals, underlining that this agreement is founded on the overall balance of benefits, rights, obligations for the Union and the United Kingdom. Now, if you go again forward to page 708, there's a heading, Article 4 of the Withdrawal Agreement. And in fact, no, I might just start before that. If you can go back a page to 706, there's a heading, the general approach to interpretation. And the court's dealing with a submission by the Secretary of State, which you see at 78, first sentence, that the upper tribunal adopted too sweeping and generous approach to construction. And at 79, Lord Justice Green says, I do not accept this analysis. The Secretary of State's argument rests upon assumptions about the subjective negotiating positions of both the UK and the EU, which it is then asserted are reflected in the agreement and which serve to govern its interpretation. I've already referred paragraph 49 above, and that's what paragraph I just referred you to the recital to the agreement, which makes clear that it reflected an overall balance. No easy assumptions can be made as to what each party was negotiating for, or as to which negotiating positions were compromised by either the UK or the EU in order to seal a final deal. The task of this court is narrow and technical. The agreement, and skipping a sentence, must be construed in good faith, ordinary meaning in their context, in light of object and purpose, and the court will then take into account any special rules of construction and implementation the parties have agreed, which obviously is a reference to Article 4 and the provisions we've just looked at. And then, just also flag a F, so if we skip down another sentence, the duty of this court is not therefore to work out whether, in the hurly-burly of negotiations, the United Kingdom or the EU got a better or worse deal in any particular respect, and then to adjust the interpretation of the agreement accordingly. And we will get there to Article 4, which is over the page. There's a heading, Article 4, Withdrawal Agreement, does it operate to exclude the operation of the Charter? And Lord Justice Green deals with various submissions that were made about the meaning of Article 4, and first of all deals with Article 4.1, and deals with the submission of the Secretary of State that Article 4.1 really goes no further than saying that the Withdrawal Agreement has to be given automatic effect in the United Kingdom, as well as having direct effect in the EU, and that submission is rejected. And the court accepts the submission that when interpreting an article of the Withdrawal Agreement, the court has to ask how it would be construed in the EU court, and then ensure that the same result would be reached in the UK court. And that submission is at B on page 709 within paragraph 85.
So would you like us to read that?
Could you read
from Ms. Demetrio,
King's Counsel
down to the end of the paragraph?
Down to the beginning of paragraph 86.
Okay. Could we just go back to Article
Yes.
4, which is presumably cited in the judgment, isn't it?
Yes.
Paragraph 52.
Thank you. So I just wanted to remind myself of where the phrase words accordingly and in particular appear.
Yes, it's in paragraph 52 on page 700 at the very top, or 699.
Okay, so it's 42. It's 4.1.
Yes.
But Miss Dimitri is really relying on the first sentence there, isn't she?
Or 4.
Yeah.
I'm sorry, my lady, I didn't.
Miss Dimitri's argument really relies on the first sentence.
Yes.
Of 4.1.
That's why I said that that's self-standing, as it were.
Yes.
It's not simply a teeing up the
Yeah.
second sentence.
Okay. Thank you.
And the way it's described just above C in that paragraph is as the principle of equivalent effect. That's the way Lord Justice Green puts it. Principle of equivalent effect.
That's how you described Article 4.1.
Yes.
Or that's how Ms. Dimitri is.
Yes, but he accepts those submissions.
Yeah. Right.
Then 86, the judge deals with the reference to methods in paragraph 4.3,
Okay.
and he rejects a submission that the reference to methods is a fairly technical, narrow concept, which, for example, involves, or which sources does one look at when one's interpreting the law? Is it the travaux and so forth? Or is methods a reference to a more general way of reasoning? And Lord Justice Green says, well, it's a reference to a more general way of reasoning, including, for example, the way the Court of Justice will interpret EU law, always to be consistent with the Charter or with general principles of
Right.
EU law. So that makes that point on the methods. And then the next point he deals with, the 87.
And this is your concepts point, is it?
It goes into, I'm less worried about methods, but it does
Concepts. This is
ties into concepts, yes. 87, fourthly, under Article 43, the general principles are relevant to construing and applying provisions of this agreement referring to union law or to concepts and provisions thereof. And we submit that proportionality is relevant to that. The Secretary of State challenges any suggestion that following UK departure from the EU, general principles have general application across, and accuses the respondent and interveners of misreading the Withdrawal Agreement. The Secretary of State accepts, however, that under 4.3, general principles can have application within the confines of the agreement. In fact, there's no real dispute about that. No party suggests they apply generally outside the confines of the Withdrawal Agreement. Nonetheless, submissions were made to the Court about the extent to which general principles remained relevant even under the Withdrawal Agreement. Now, the Court's really only here concerned with general principles under the Charter, because that's the whole crux of this case in terms of Article 1 of the Charter and the right to dignity. So that's what the Court's got in mind. And then in the following reasoning at 88, and I won't go through it, but the thrust of that reasoning is that where the court is interpreting provisions of EU law, it will ensure that they are interpreted consistently with the Charter as a general principle.
Right.
Now, can I just take one other point for the time being from this judgment, which relates specifically to Article 13 of the Withdrawal Agreement. Perhaps we can just look at Article 13.
We haven't looked at it yet, have
No,
we?
we haven't, so probably should just look at it first. Probably is referred to.
Do you want us to look at it in the judgment or go back to?
If we go, can we go back to it, just because I
Yes.
think it's useful to have it marked up in one place rather than multiple places. So it's page 144, and this is the provision which creates residence rights under Article 2, Chapter 1.
Yes.
So Union citizens and United Kingdom nationals shall have the right to reside in the host state under the limitations and conditions as set out in Articles 21, 45, 49, Treaty on the Functioning of the EU, and then various provisions are cited of the CRD.
Mm-hmm.
Now, there was an issue in the AT case about whether this is essentially creating an independent withdrawal agreement right to reside, or whether it's importing, as it were, grandfathering over the right to reside under EU law. An article, in particular, Article 21, is the right under EU law to move and reside freely,
Yes.
okay, within the EU. And it turned on an interpretation of the words used there. Now, this has been decided by this court, so we don't need to go back over it, but just to show you what the court decided, it's paragraphs 93 and 94 of this court's judgment in page 712. The Secretary of State...
Sorry, just forgive me, I've lost. Say that page number again.
712.
Thank you.
So the Secretary of State was arguing, first sentence 49, as I've said, that Article 13 created, as it were, a standalone withdrawal agreement right of residence, which didn't bring through or grandfather any Article 21 TFEU rights, but only the limitations. So all Article 13 was doing was saying you have a right of residence subject to limitations under Article 21, various provisions of the CRD. This court rejected that submission. 94. In my judgment, Article 13 is not self-standing. By its language, it brings Article 21 into effect through cross-reference. The Secretary of State reformulation alters the substance of that right. It allies limitations with conditions, when naturally read conditions indicates that the right as defined in Article 21 is brought forward. So when Article 13 says Union citizens, UK nationals, shall have the right to reside in the host state under the limitations and conditions set out in 21. The reference to conditions means essentially you enjoy it in the same way as you enjoy the Article 21 right. When you enjoy the Article 21 right, you enjoy your right to reside under the withdrawal agreement. So that's how this court interpreted it then. So it's not a freestanding right, it's bringing forward Article 21, and then the court then, you don't need to go through it, but the court then finds it fairly easy to interpret restrictions on that right, such as the denial of universal credit, leaving the claimant destitute, as having to be compatible with the Charter, brought in Article 1 of the Charter, and the right to dignity. And ultimately the court found that there was a breach of that right. So, drawing some of the threads together, my lord, and my ladies, in relation to AT, in terms of the general principles. First point, the withdrawal agreement is the product of a bargain negotiated in the hurly-burly of negotiations. It reflects an overall balance. It is wrong, therefore, to interpret it by reference to assumptions about the intentions of the negotiating parties. That's paragraph 80. And my submission is that it also means that when you're approaching the withdrawal agreement, you don't do so as if it's a piece of legislation. It's not a legislative instrument. It's a bargain between two parties produced in the stressful circumstances where both are trying to reach an ultimate goal.
It has to be interpreted according to under the principles of the Vienna Convention.
Yes, it's a treaty. It's a treaty. The approach of the court is to interpret the text according to its ordinary words in its context. That's paragraph 80. Thirdly, Article 4.1 sets out a principle of equivalent effect, as I've said. That requires this court to ensure that the interpretation would be the same as a court in the EU would interpret the agreement. And that's relevant not just to the way you approach the task of interpretation, but when I come on to make my submissions about reference to the Court of Justice, that's of obvious importance. Article 4.3 methods is not limited to technicalities, but includes broad interpretive methods, such as interpreting EU concepts consistently with general principles of EU law. My Lords, we also have a point which is not one of the sort of overarching points, specifically in relation to Article 21, which is that Article 21 is given effect through Article 13, and Article 13 doesn't create, as it were, a discrete freestanding right of residence under the withdrawal agreement. It's giving effect to the EU right of residence to move and reside freely. And so those are the core propositions that we derive from AT. So taking those forward, then I turn to my submissions in relation to ground 2, which I said I would take first. I've made the point that this is a general importance because it applies not just to UK citizens here, but foreign citizens here, but it applies to UK citizens who are exercising their withdrawal agreement rights throughout the EU. And we say that on the Secretary of State's case, the withdrawal agreement rights of those people are very substantially hollowed out. Because going forward, the Secretary of State is correct, then any state, whether it be France or Hungary or the United Kingdom, can pass legislation which can restrict, including by expulsion, the withdrawal agreement resident rights of those enjoying those rights, as long as it's on grounds of some conduct. There is no other restriction. The only other restrictions are the very minor ones of notice and appeal. Can we start, before going back to Article 21, with the CRD? And that's in tab 22 of the authorities bundle. Article 6 provides a right of residence up to 3 months. Union citizens shall have the right of residence in the territory of another member state for a period of up to 3 months. And that's extended to the family. Article 7 is a right of residence on the territory of another member state for a longer period where people are economically active or are have sufficient resources and in the circumstances set out in Article 7. But we have a up to 3 months, we have more than 3 months. And Article 16, which is in Chapter 4, it sets out a right of permanent residence for union citizens who have resided legally for a continuous period of 5 years in the host member state.
Yeah.
So there's a series of residence rights with different conditions. Article 15, so this is in relation to, applies under Chapter 3, it's at page 225, sets out procedural safeguards. The procedures provided for by Articles 30 and 31 shall apply by analogy to all decisions restricting free movement of union citizens and their family members on grounds other than public policy, public security, or public health. So it's quite a sort of a catch-all provision. Point 2, expiry of the identity card or passport on the basis of which the person concerned entered the member state and was issued with a registration certificate or residence card shall not constitute a ground for expulsion. And then point 3, the host member state may not impose a ban on entry in the context of expulsion decisions to which paragraph 1 applies. So that's the sort of a general provision, as we'll see. There are more specific provisions relating to measures taken on grounds of public policy, public security or public health in Chapter 6. If you go forward to page 232, into Chapter 6, this chapter concerns restrictions on the right of entry, the right of residence on grounds of public policy, public security, public health. First of all, Article 27, general principles. And that's contrasted with Article 28, which is specifically concerned with expulsion, and Article 29, which is concerned with public health. So it's a more general provision. Subject to the provisions of this chapter, member states may restrict the freedom of movement and residence of union citizens and their family, irrespective of nationality, on grounds of public policy, public security and public health. These grounds shall not be invoked to serve economic ends. There's a reference to restriction, and there's a reference to grounds, setting out the grounds. Point 2, measures taken on grounds of public policy or public security shall comply with the principle of proportionality and shall be based exclusively on the personal conduct of the individual concerned. And that's because of this provision and the other provisions I'm going to show you and we're going to have a look at carefully, is why I talk about CRD proportionality, because proportionality under EU law is context specific and it has somewhat different meanings in different contexts. And in relation to residence rights, citizens' rights, it has a developed meaning. Previous criminal convictions shall not in themselves constitute the grounds for taking such measures. Personal conduct of the individual concerned must represent a genuine, present and sufficiently serious threat affecting one of the fundamental interests of society. So then you get this hurdle that has to be surpassed if you're relying on personal conduct of the individual. Justifications that are isolated from the particular case or that rely on general prevention shall not be accepted. And then Article 28, which I've said deals specifically with expulsion decisions, sets out again a sort of tier of severity of conduct that one needs to have committed in order to be expelled, depending on your length of residence. Point 1 begins by saying, before taking expulsion decision, I'll come back to this, but it's important that it has to be taken before an expulsion decision has been taken. on grounds of public policy, public security. The host member state shall take account of considerations such as how long they've resided on the territory, age, health, so forth and so forth, personal characteristics. The host member state may not take an expulsion decision against union citizens or their family members who have the right of permanent residence, except on serious grounds of public policy or public security. Again, reference to grounds there. An expulsion decision, this is point 3, may not be taken against union citizens if the decision is based on imperative, except if the decision is based on imperative grounds, if they've resided for 10 years or a minor. So if you've got permanent residence, you've been there for 5 years, you've acquired your permanent residence, it's got to be serious grounds, 10 years, imperative grounds, minor, imperative grounds. And then Articles 30 and 31. Article 30 relates to notification of decisions. The person concerned shall be notified in writing of any decision taken under Article 27.1. It's only a notification of a decision taken under Article 27.1 in such a way as they're able to comprehend the content and the implications. So, very general requirement. The persons concerned shall be informed precisely and in full of the public policy, public security, public health grounds on which the decision is taken in their case is based, unless contrary to the interests of state security. So that is a notification requirement, but depending on the grounds could be very general. In the case of the 2007 Borders Act, for example, if you're notifying someone why they're being deported, it is simply you've committed an offence that has a term of imprisonment of more than 12 years. Stop.
12 months.
12 months. Article 31, headed procedural safeguards. First of all, access to judicial and administrative redress procedures, where appropriate administrative redress procedures, to appeal any decision taken against them on grounds of public policy. So you have a right of appeal to a judicial tribunal. And then there's a specific provision which I would ask you to read, but I won't read out, in relation to applications for interim orders to suspend enforcement. And Article 31.3, the redress procedures shall allow for an examination of the legality of the decision, as well as the facts and circumstances on which it is based. Full stop. So that there has to be an examination of the facts and circumstances. And you have to read that in my submission together with what we've seen in 27.2, general provision, exclusively based on the personal conduct of the individual concerned. And what is said in 28.1 about how long somebody has been present, age, so forth. So when this is referring to the facts and circumstances, it's clearly referring back to those provisions. And then it states they shall ensure the decision is not disproportionate, particularly in view of the requirements laid down in Article 28.
Yes.
Now, can I take you to case at tab 56?
So we're moving to the other bundle.
Moving to the other bundle, I'm afraid. It's a case called Centulia. decision of the CKU yes, was decided before the withdrawal agreement was concluded. And it concerns, perhaps I can just ask you to read the first paragraph of the head note so you get the facts on page 1347.
You said it was decided before the
Yes, it's decided.
withdrawal agreement was concluded, did you?
Yeah, it's 10th of September 2019. And the withdrawal agreement was signed on 19th of October 2019.
All right. You want us to read the head note?
Yes, please. Just the first, don't worry about the holding, but just the facts.
The facts, okay.
And the question, as defined by the court, is at paragraph 50 on page 1383. The referring court seeks to ascertain in essence whether the provisions of Chapter 6 of Directive 2004/38, in particular Articles 27 and 28 thereof, and Articles 14 and 15 of the Directive, are to be interpreted as meaning that one or other of those sets of provisions, so you're either in Article 15 territory or you're in Article 27/28 territory, are applicable to a decision to expel a third country national on grounds that the person no longer has a right of residence under the directive in a situation such as that issue in the main proceedings where the third country national concerned married union citizen at the time when that citizen was exercising rights of freedom of movement by moving to and residing within the third country with that third country national and host member state, and subsequently that citizen was returned to their member state. So they've come over exercising EU free movement rights, but they no longer have them. And Ireland was basically saying, well, you don't have the rights anymore, so we're going to return you. And the court finds, if you look, starting with 71, refers to Article 15 of the directive, which we've looked at, which is entitled Procedural Safeguards. It makes this point in paragraph 71. And it provides in paragraph 1 thereof that the procedures provided for in Articles 30 and 31 of the directive are to apply by analogy to all decisions restricting the free movement of union citizens and their family members on grounds other than public policy, public security, public health. And then at 73, according to the very wording of Article 15, and on pain of depriving its provisions a large part of its substance and practical effect, the scope must extend to an expulsion decision made, as in the main proceedings, on grounds wholly unrelated to any danger to public policy, public safety, so forth, but which are connected to the fact that the family member who in the past enjoyed a temporary right of residence deriving from the exercise by the union citizen of his right to freedom of movement now no longer has such a right. So all that's been decided is you no longer have a free movement right, you've got to return. But the court said you still have to apply Article 15. You're still within the scope of Article 15, just from the mere fact that you've exercised in the past a free movement right. And you see at 76, following the departure of her spouse, she lost the right of residence. She no longer satisfied the condition requiring that she accompany or join the union and exercise his right or freedom of movement, which led to the rejection of her claim, seeking a right of residence under Article 7 of the
Sorry, where were you reading?
76.
Thank you.
77 at E, the host member state may make an expulsion decision regarding Miss Centulia under Article 15. However, such a decision may be taken only in compliance with the requirements laid down in that provision. And then at 80, the court turns to the consequences of the fact that Article 15 is applicable as it's held. And what does it say are the consequences? Well, there's the reference to Article 31. And at paragraph 85, the court says, in accordance with Article 31(3) of Directive 2004/38, which is applicable, in connection with Article 15 thereof, the redress procedures must not only allow for an examination of the legality of the decision concerned, as well as the facts and circumstances on which it is based, but also ensure that the decision in question is not disproportionate.
Now, where were you then reading from? Forgive me.
I'll say 85, paragraph 85.
Thank you. It's not marked.
No, I don't.
Don't worry. Just slightly difficult.
I know, it's
Skipping
it's a shame
past
it's not
marked
because
passages.
if there's one paragraph of any authority in this case, which is the most important paragraph,
It's 85.
this is that paragraph.
Is it?
Perhaps you can sideline it twice. So no,
I'll put a
apologise if
star
wasn't
by it so
sidelined.
that I know that that's your main paragraph. 85.
Yeah.
Well, I'll now read it. Right. Thank you.
And then it goes on in 86 to say that you apply proportionality under 31(3) through, as it were, the conduit pipe of Article 15, even though Articles 27 and 28 are not in play. So Articles 27 and 28 are not applicable to this decision.
Yes.
And then at the bottom of 89...
So 80 is an important stepping stone to 85, isn't it?
Yes, it is.
Help me just to look again at 15. It's in, without going back to the other bundle, it's presumably in here, isn't it?
Paragraph 30.
There we are. Thank you.
So, yes, paragraph 13. So it's headed procedural safeguards, which is important. And it then says the procedures provided for by Articles 30 and 31 shall apply by analogy. And again, there's reference there to the procedures in 30 and 31. And what the court then does is say, we apply that to this individual, even though this individual's no longer got any free movement rights, but we're going to apply it because they have exercised them. And the procedures that are imported from 31 of the CRD include proportionality.
Yeah.
So this is a case where the court has interpreted Article 13, so Article 15, and the reference to the procedures in Articles 31 that it applies by analogy. And it's decided you apply proportionality as one of those procedures.
It's sort of interesting as a matter of drafting that Article 31 Article 31(3) treats proportionality or ensuring that the decision isn't disproportionate as part of a procedural safeguard.
Yes, it does.
See Mr. Cox nodding.
Well, it does.
Sorry, it's a bit of an obvious point.
I mean,
You know, a
the
penny has perhaps dropped there.
one has to leave one's common law preconceptions about what is a procedure at the door, and you have to come into the EU world where the CJU is very clear and finds that a procedural protection
Includes concepts.
includes
concepts.
proportionality, and not
But
just
that's a concept that comes from the directive itself.
exactly, and it's
Yeah.
interpreting.
So it's not kind of something the CJ's invented.
No, but
You get there, Var. Article 31 treats it as part of the redress procedures,
Yeah.
doesn't it?
But I think the point that's made against is, well, the directive sort of has a mixture of what described as substantive. I don't really want to use that word, 'cause I think that's not part of any of the materials. Like, misleading, but described as substantive and procedural.
Yeah.
I think the correct analysis is grounds and procedures. Okay? Let's adopt my phraseology. You go through the directive, and Article 21 tells you effectively to prune out what is a ground, and you leave what's a procedure, and you apply what's a procedure. What's said against me is no, you take out what's substantive, and you leave what's procedural, and you have to do that pruning exercise through all the provisions of the CRD. So what's said against me is when you get to 30.3, you take out the reference to proportionality.
Yes. So it's different meanings of the word procedure, is it?
Well, fortunately, we have the answer because it's here. CJ
That's the difference. That's a difference between you and Miss Smythe.
Yeah. Well, so
I don't think Miss Smythe would be offended by that rather dismissive gesture.
no, I didn't mean that way. I mean, there are all sorts of differences.
No, you see much more up here, Miss Smythe.
we have, there are all sorts of points that they take, which I'm going to have to address.
It's a serious point. This is right at the heart of the
This
case.
is very central. This is the very central. In my submission, I mean, maybe that Smythe has a different perspective, but that's how we see it. And then just to complete this, at the bottom of 89, it follows that the relevant safeguards laid down in Article 1331 are applicable when such an expulsion decision is adopted, and it's not possible under any circumstances for a decision to impose a ban on entry to territory. That's the reference to 15.3. But it's clear that the safeguards that are imported, the procedural safeguards that are imported by Article 15, include the proportionality principle mentioned in 31.3, and that includes the individualised circumstances that we've seen. It's not just the mention of proportionality, but it's the need to examine the facts and circumstances of a particular case.
Just pause it just a second, Mr. Hickman. Just allow us to take stock for a moment. At the heart of your case is that proportionality is a procedural safeguard. It's a safeguard. Procedural is a safeguard.
It's procedural safeguard.
Thank you.
CRD proportionality, the particular way that proportionality is articulated in the Systems Right Directive.
Yes.
So let's go back to the withdrawal agreement, tab 17.
Right.
Can you, will you come back again to what you mean by CRD proportionality?
Yes, I absolutely will.
Because that's, I have to say, I'm rather struggling with what bits of the CRD you pick out for that purpose.
I will do that. What I'd like to do is just go to the withdrawal agreement. Then when we go to 21, we then go back to the CRD, and I'll tell you which bits we say are procedural safeguards. And in doing that, I can, I think, hopefully explain a little bit more.
If I may say, in Centulia, the exercise seemed to be a little bit more straightforward because you're specifically told to ignore the public safety, etc. grounds.
Yes.
And I can see how the CJEU decided it, how they did, but I need a bit more help.
Yes. So, because obviously that was a case which didn't involve a decision taken on the basis of public
No.
policy,
Indeed.
public security.
Yeah.
So then you have to say, well, when you have got such a case, how do you get into Article 27?
But take your own course. I just wanted
Okay.
I
to
do
flag
propose to do that.
Right, so back to the withdrawal agreement for the
Withdrawal
moment.
agreement. So the way it works is in Part 2, which is citizens' rights, at page 141, you have Article 10, which sets out the personal scope. So it tells you who acquires a withdrawal agreement residence right. And then at 144 over the page, Article 13, and we've already had cause just to look at this briefly in relation to the AT judgment.
Yeah.
This is the article that confers the residence right. And you can just look briefly at Article 13, paragraph 1. But ultimately, this court has recently told you what that means, and I've taken you to that paragraph.
Yes, Lord Justice Green.
Lord Justice Green,
Yeah.
with the agreement of the other two members of the court, so it's unanimous judgment.
Yes.
And it's basically saying this is
Not a freestanding right.
not a freestanding right. It brings forward the right to move and reside freely from Article 21 of the Treaty on Functioning.
Underline conditions. The word conditions. Yeah. Yes?
Article 15 confers the right to permanent residence, individuals who've resided for 5 years, and Article 16, accumulation periods, that's essentially the pre-settled status idea. You know, you can acquire your permanent residence
Yes.
in time. Now, let's go to Article 20, page 150.
Right. Yep.
Let's make a few general points about Article 20. First, and some of these may be, I'm sorry if I'm making obvious points, but I think it's important just to make sure we're clear. First of all, it's not concerned with expulsion specifically. Okay? Article 20 and Article 21 are concerned with any restrictions on entry or residence rights. It's important not to look at it through the prism of expulsion. In one sense, it's analogue in the CRD as Article 27, which is the general provision in relation to conduct. Secondly, even more obviously, it's not a provision that's specifically concerned with prisoners. And I make that point because when we look at the upper tribunal judgment, they seem very much to be looking at it through the prism that this is concerned with people who are in prison. And it sets out a right under Article 20.2 that is going to be the most important right because it refers to conduct that's post IP completion day. And it says that a person can have their rights restricted, the rights of residence restricted by the host state, or the right of entry in relation to conduct that postdates completion date. But it has to be conduct. So it does limit the ability to restrict rights to conduct. If you look at the distinction between Articles 20 and 20.1, 20.2, the distinction is that Article 22 says that the grounds, conduct-related grounds, are set out in national legislation, can be set out in national legislation. Whereas 20.1 is very clear that you have to be under Chapter 6 of the CRD. So essentially what that means is that Article 20.2 allows national legislatures to widen the grounds of conduct beyond the relatively narrow conduct-related grounds that we've seen in the CRD.
Yes.
There's in my submission there isn't here any reference from which you can infer even that a distinction is being drawn between what we would understand in the common law tradition's procedure and substance. There is no basis for that in these provisions. It's very clear. The distinction between the two relates to the grounds on which a person can have their residence rights restricted. It's got to be conduct in both cases, but where the conduct occurs after completion day, the grounds and the conduct can be wider than those in the CRD, and that's a material distinction between the two provisions. And we don't suggest that they have that the people whose conduct is committed after completion day are in the same boat, because obviously the grounds on which they can have their rights restricted are potentially wider. So there is a fundamental difference between the two situations. And bringing proportionality into play, that doesn't affect that.
Can I just understand that? Because you referred earlier to the potential for national legislation to be passed that, as long as it relates to conduct, could provide grounds. On the face of it, there is no restriction in the withdrawal agreement on the ability of a government to pass that legislation. And I think it probably comes back to the point I was asking earlier. Really, the question is, if you say proportionality is a procedural safeguard, how do you apply it in the context of national legislation, which on the face of it, governments have a broad discretion to introduce?
Well, you applied in precisely the way that the first tier tribunal did here. You can engage meaningfully in a proportionality balancing assessment between the right of the individual, their residence right. You look at how long they've been here.
But what the FTT seemed to do was apply Chapter 6.
Well,
that comes to the core of the problem, it seems to me.
Well, in my submission, and I'll obviously have to address you on the ruling, on the reasons that were given, but my submission that, in fact, they don't apply the relevant higher thresholds. They don't do that. They just apply straightforward proportionality analysis. But in any event, you get there.
I think again, I'm just repeating myself. I really need I need your help on what that means.
Yes, okay.
In this context, but I'll let
we'll get there. But you clearly can do a proportionality analysis. Obviously, that will restrain the measures that can be taken, because that's the nature of it. It will restrain the measures that can be taken by national states. And you couldn't have a blanket measure, because a blanket measure that said all people within a certain category would displace the right of individualised consideration, and you consider the individualised circumstances. And so you wouldn't allow that. That's why this is so important, because if you don't have that individualised proportionality analysis, which we say is carried forward, then you really end up with almost nothing. And the withdrawal agreement rights would be hollowed out, because they could be just taken away by national legislatures without anything really to restrict that.
Are you to an extent helped by the current scheme? Because the 2020 regs, assume for a moment, and obviously we don't know the answer to this yet, but assume for a moment your construction of the withdrawal agreement is correct, the appeal via the 2020 regs is a route to vindicating whatever you've got under the withdrawal agreement.
Yes.
So there isn't a kind of domestic procedural difficulty in the current scheme.
No, there's not. No, exactly. I mean, it essentially doesn't make a huge amount of sense trying to interpret the agreement in a sensible way. For there to be all these incredibly detailed procedures and protections within the withdrawal agreement. Who has withdrawal agreement residence rights? Taking them forward. The whole title is dealing with these rights. If every legislature of every country that's bound by this agreement could just simply say, well, anyone who commits some minor infraction is on their way back. And that would hollow out the protections of the withdrawal agreement enormously. So that's the distinction we say. The distinction is one of grounds. You can have wider grounds in relation to conduct that postdates the completion date. And furthermore, it's also worth looking at point 3. The host state or the state of work may adopt the necessary measures to refuse, terminate, or withdraw any right conferred by this title in the case of abuse of those rights or fraud, as set out in Article 35 of the directive. Such measures shall be the subject of procedural safeguards under Article 21. Now, Article 35, I don't think we looked at, but if you just turn to that at tab 22 of the bundle, at page 239. So this is a Chapter 7 provision. So it's not brought in by reference to Chapter 6. The abuse of rights. Member states may adopt the necessary measures to refuse, terminate, withdraw any right conferred by this directive. In the case of abuse of rights or fraud, such as marriages of convenience, any such measures shall be proportionate and shall be subject to the procedural safeguards provided in 1331. So there's a reference to proportionality. There's also a reference to the additional protections in Article 1331, but it's clearly reference to proportionality. Now, it doesn't make any sense, in my submission, for you to undoubtedly be subject as a state to a proportionality requirement in cases of restrictions on rights based on fraud, but not in relation to all other conduct. All other conduct.
Yes, right.
Article 21, safeguards and right of appeal. It's relevant to note that it refers to safeguards in the plural, in addition to a right of appeal. That suggests that there is a package of measures. And it is difficult, we say, to work out what the plurality of safeguards would be on the Secretary of State's case. Refers to Article 15 and Chapter 6 of the directive. And therefore, that's why I say that the CJU decision that we were looking at, Centulia, is particularly relevant because Article 15 is given express application here. And we know what that brings in because Centulia tells us. Now, let's go back to Chapter 6 and I'll try and answer my lady's question. What are the safeguards in the CRD? Well, first of all, we go to page 225, Article 15. Now, to be clear, we say that the exercise that one has to go through in relation to Article 21 is you have to go to Article 15 and you have to go through Chapter 6. And what you have to do is effectively blue pencil grounds. Okay? Because Article 20.2 tells us that in relation to conduct post-state's completion day, the grounds can be set out in national legislation. So restrictions on grounds are not imported by Article 21.
Sorry, can I just clarify one point? We're going to Article 15, but it's not said that that's directly applicable here, is it? Or
Well, I think because the way it's been analysed, this case, is that it would be a public policy restriction because it was on the basis of criminal offending. So Article 15
sorry, I'm
would
asking
not,
a different question. Article 15 is part of Chapter 3.
yes.
Is that...
Yes, because it's expressly in Article 21, it says Article 15.
No,
or
I
chap- and chapter
appreciate
6.
that, but I suppose I hadn't really appreciated whether Article 15 is directly applicable on the facts of this case.
No, probably not, because
Well, that's what I thought.
this is a public policy case.
Yes. So,
So I
why are we concerned with Article 15
Well,
at all as opposed to Chapter 6?
well, because it tells you that proportionality comes into play through Article 31 for a start, and it's accepted between both sides that Article 31 applies. So whatever the procedural protections in Article 31 are, they apply. And the CJU tells you that the procedural protections in Article 31 include proportionality. So that's one of the reasons.
Well, yes, I understand you rely on it as part of the interpretive exercise. I was asking a rather more basic question about whether it's directly applicable on the facts of this case.
No, I'd accept that it's not, because this is a public policy decision. But you have to look at it, because in order to understand what the safeguards imported by Article 21 are, you have to look at Article 15 and Chapter 6. Because that's what it says. It talks about the safeguards in Article 15, Chapter 6. And they mesh together, as we've seen and we'll see. So, Article 15, it's headed procedural safeguards.
Yeah. 15.1.
Yes. Now, where 15 applies, where it applies, we fall out. If it's not public policy, public security, then it gives effect to Article 31 and the procedures in Article 31. We looked at Centurion. And it also has this provision, host member states may not impose a ban on the entry in the context of an expulsion decision to which paragraph 1 applies. So that would, we say, be a procedural safeguard. Paragraph 2 is probably a ground. So, would not be within the safeguards imported in relation to conduct post completion day. If we then turn forward to Chapter 6 at page 2 through 2, Article 27, paragraph 1 would not be applicable, because that's grounds, would not be applicable.
Can I just, it may not matter, but when you said you blue line all the grounds, is that really right? Because Article 20 sub 2 is permissive that you can use national legislation to introduce grounds.
Well, maybe that's not a very accurate way of me putting it, because I accept that in order to get to Article 27.2, you have to go through, as it were, the gateway of Article 27.1. So a decision has to be taken on the basis of public policy.
Yeah.
But what I mean to say is that Article 27.1 doesn't limit the grounds to those specified therein. So whereas under EU law, you're limited to those grounds, yeah, based on conduct. You're not so limited in relation to post-completion day conduct. But if it's not on those grounds and you go to Article 15, if it is on those grounds, falls within those grounds, but not limited to those grounds, then you go to 27.2. And we say 27.2 applies to measures taken on grounds of public policy, public security. They shall comply with the principle of proportionality and shall be based exclusively on the personal conduct of the individual concerned. So we say that sentence is procedural safeguard.
And sorry, just so I understand your argument, you say the ground in this particular case related to criminal convictions is a measure on grounds of public policy.
Yes, I think I would have to say that.
So you say because proportionality is a safeguard,
Yeah.
we have to apply the first sentence of 27.2.
Yes. Now we also say you should apply the second sentence. Now I can see that there's obviously an exercise here of working out which parts you have to apply in an individual case, but the second sentence is a facet of the requirement of individualised consideration.
But doesn't that directly run against Article 20 sub 2?
Well, no, because you need to look at the individualised circumstance. A person might be able to say, well, yes, I committed this offence, but there's something about my particular circumstances that would make it disproportionate. You've always got to allow them to make that argument.
But I didn't understand your submissions to be, in effect, that the national measures that deem deportation to be conducive to public good where there's a conviction were completely outlawed by this provision. But that's effectively what you have to say here, because you say, well, I can't use a criminal conviction.
Well,
that's really what the second sentence is saying.
No, it says that it's not in itself.
Yeah.
So it all
But-
depends on the nature of the criminal conviction. And
yeah,
the circumstances.
exactly. The nature of the criminal. The nature of the criminal. But
So,
we would
so
still.
you couldn't say the mere fact you've been convicted of a speeding offence is grounds for chucking you out. Isn't that what it's getting at?
Exactly.
No,
Well-
well, I'm not sure. I mean, it depends whether you read criminal conviction generally or specifically. I mean, it's
Do we mean in themselves as meaning by themselves? Is that what it means?
Well, even put in the stronger way, there may be extremely mitigating circumstances, even if someone's committed a criminal offence. So we say you always have to look to provide an opportunity for an individualised consideration of the facts.
But just to return to the point, I didn't understand your case to be that the Secretary of State can never deport a previously convicted criminal who's been sentenced to more than 12 months imprisonment. Rather, they can, that's a potential ground, but you need to do an individualised assessment. So this seems to, if you're right, the second sentence applies, it seems to be inconsistent with that. Because the starting point, the ground, is a previous criminal conviction.
Yes, but you need to make sure that there's nothing, as it were, in the scales on the other side. That's the individualised assessment. And as long as the Secretary of State is satisfied that there's nothing in the scales on the other side, then the person is...
Well, I'm not sure I see that, particularly when the previous sentence has specifically brought in proportionality, which is, that's your point about individualised assessment.
Well, we say the first sentence is included. We say the second sentence is also included, but in the alternative, at least the first sentence is included. Article 28.
Sorry, and the second paragraph of 27.2.
Yes. So
Presumably you don't say that applies.
No, we accept that would be a ground. because the way that the Citizens' Rights Directive works is it has this sort of heightened concept of public policy, public security, and in order to take action restricting the rights of people under EU law on grounds of on those grounds, you have to overcome a higher hurdle, and we accept that would not be imported into our law or the law of any state in the EU because of the effect of Article 20.2.
I mean, on one view, the grounds under 27 are simply public policy, public security, or public health.
On one view.
What would you, going through how far you want to go 27, will you identify what the grounds are and what are the
yes, okay. Well,
safeguards?
Second paragraph there, we have accepted and do accept is a ground.
What is?
From the personal conduct of the individual concerned through to the end of that sentence.
So
that's
the whole of the first paragraph of 22, of 27.2 are grounds. Is or are grounds.
I'm sorry. So the whole of. So we're looking at point 2 on page 233.
Yes.
The first sentence, measures taken on grounds, is a safeguard.
Sorry. Measures is a safeguard. Yes.
Previous criminal convictions is a safeguard, but if you're not with me on that, alternatively it's not. So I win either way.
Or you lose either way.
Or listen, yeah. The personal conduct of the individual concerned is a ground, genuine present, sufficiently serious threat, that's a ground. And then justifications that are isolated from the particular case or rely on considerations of general prevention shall not be accepted, we say is a ground.
Well, I find
Something you to think about over lunch, Mr. Hookman.
This is, I mean, obviously, this is an exercise that's forced upon us because of the way that Article 20.2 and 21 of the Withdrawal Agreement are framed. But the difficulty, of course, is this document wasn't designed with this problem in mind.
Yes, but Article 21 was presumably drafted with
in the hurly-burly. This is the problem that's been left. Been left to this court to work it out. Just to quickly.
When the hurly-burly is done, in my
just,
mind there,
when the
I have to
battle's
be
fought
very
and won.
careful, everybody.
I have to say, I find the thought that the second sentence,
Right.
the thought that the second sentence is a ground, I find very difficult. You'd think it might be a safeguard.
Article 28(1) is safeguard.
'28(1). Safeguard. Yeah.
And 28(2) and 3 are grounds.
Is it fair to say that of all of these, what you really need or most need is 28(1)?
Or 27. I mean, so I was going to come back and can we quickly go through them? Tell you which is ground and safeguard, and then I'll just make the point that my lady asked me about the proportionality, how it has a different meaning.
I missed a trick because I wasn't paying attention. 28(1) is a
Safeguard.
Yep, thank you.
And 28(2) and 3 are grounds.
Yes. Article 30 is 1 and 2 are both safeguards.
Yes.
But they're linked to Article 27. So you can see the way that's linked there. Article 31 is a safeguard, but it may be that 31 paragraph 2.3 is ground. 31 paragraph 2.3
Where the expulsion decision.
based on grounds of public security.
Okay. And
It's
do
not
we-
relevant to us anyway. But paragraph, importantly, 31.3 is a safeguard, and that's Centulia.
Sorry, could I ask Mr. Hickman to repeat, because I've got to answer this, and it's not in writing, and I've slightly lost where we are and what's a ground and what isn't in Article 31.
So all of 31 is a safeguard, including importantly 31.3. I just mentioned that 31 paragraph 2 sub point 3, where expulsion decision based on imperative grounds of public security, could argue it was a ground, but it's not relevant
Okay,
to us.
so what we're trying to do is identify the safeguards in the CRD, to which Article 21 of the Withdrawal Agreement is referring.
Yes, or you could put it the other way around. Article 21 imports Chapter 6.
But only
Of the
insofar as they are safeguards.
Yes, and as far as they're safeguards.
So it ought to be possible to extract a list, following your submission, a list of the safeguards in Article 15 and Chapter 6, which are imported, your word, into the Withdrawal Agreement.
Yes.
You could do that, could you, by 2 o'clock for us, in a little list with someone sitting behind you.
I certainly can. Can I just go
This
back
is,
to my...
this is the crux of your case, isn't it?
Well,
You want us to
it
go
is.
through all this. Say, these are the procedural safeguards imported into the agreement, and that's what's required here. Importantly, proportionality.
My lord, yes, but with this caveat that there are obviously provisions here that don't affect my case, and so in which there may be arguments either way, which are not relevant to my case. What I'm arguing for is 27.1, 28.1, 27.2. I'm sorry, I get myself confused now. 27.2, first sentence in particular, and 28.1 and 31. They're the critical ones for me.
I know, but it may well be that the analysis of the rest of them is necessary to test the validity of your construction.
Could be, my lord. In my submission, it's very clear that one has to do this exercise of grounds and safeguards. But I don't, in my speech, it's not necessarily to work out definitively now where all of the provisions fall in that dichotomy. What's relevant to me is 27.2, 38.1, and 31.3. They're the critical ones for me.
Okay. It would still, for my part, assist me if you could draw up a list of of the safeguards.
Yes.
If you could do that. I won't say by 2 o'clock, but at some point during the hearing, so that we can get a sense of what this means for the interpretation of the agreement.
And can I just deal with this point about proportionality? Because proportionality has contextual meaning in EU law. And I can show you Lumsden in a minute, where the Supreme Court look at it, and that's one of the points they make. But if you look at 27.2, for example, measures taken on grounds of public policy, public security shall comply with the principle of proportionality and shall be based exclusively on the personal conduct of the individual concerned. Now, we're concerned not only with proportionality stricto sensu, as it were, but with the need for exclusively personal conduct of the individual concerned, which I'm referring to generically as CRD proportionality. and it is given a slightly different formulation in 28.1. Before taking an expulsion decision on grounds of public policy, public security, and so forth, the host member state shall take account of considerations such as how long the individual concerned has resided on its territory, age, state of health, family, economic situation, social, cultural integration into the member state, and the extent of links with the country of origin. So that's more prescriptive about what has to be considered
On an
in
expulsion,
Expulsion.
as you'd expect.
as one.
Well, yes, 27 is general principles, 28 are specifics, isn't it?
Yes, but it's still that requirement of very individualised consideration. which
Indeed.
You don't necessarily always get with proportionality. Just show you London, it's at tab 26. The nature of the case doesn't matter. What's relevant is what Lord Reid and Lord Toulson say about the principles of proportionality. It's tab 26, and if you turn to page 298, so it's clear from the beginning of paragraph 23 under the heading Proportionality in EU law that Lord Reid and Lord Toulson are setting out to give some general guidance on the meaning of and effect of proportionality in EU law. Third sentence, it should be said at the outset that the only authoritative interpreter of that principle is of course justice, point I'll come back to in due course, and then skipping over the next sentence, it also has to be said that any attempt to identify general principles risks conveying the impression that the court's approach is less nuanced and fact-sensitive than is actually the case. As in the case of other principles of public law, the way in which the principle of proportionality is applied in EU law depends to a significant extent on context. And then paragraph 24 refers to the fact that proportionality is a general principle of EU law. And if you go forward to paragraph 33, there is a sort of generalised statement of the test, as it were, in the first sentence of paragraph 33, but that's subject to what's been said about context. And after setting out that general principle, over the page, at the end of paragraph 34, Lord Reid and Lord Toulson return to the context. They say, the court's case law applying the principle in one context cannot necessarily be treated as a reliable guide to how the context will be applied in another context. It's necessary to examine how, in practice, the court has applied the principle in a particular context. And so what the CRD is doing in those provisions, Article 27, Article 28, is essentially codifying pre-existing CJEU case law, which has applied proportionality in those particular contexts. So that's why I prefer to talk about CRD proportionality rather than generically EU proportionality. Can I also just make the point where we've got this authority open? If you look at paragraph 26 at page 299, the court makes the point that proportionality is not equivalent to ECHR proportionality, either in its formulation or its effect. You could take the core bundle, tab 5, and the Secretary of State's skeleton arguments. Para 55, which is on page 67 of the bundle, you can see in little Roman 2 that the Secretary of State accepts that Article 31 is imported.
Yes,
by the
headed procedural safeguard.
But what the Secretary of State's argument is that you take out the reference in 31.3 to proportionality. And it's at that point that we part company, because we say that the reference to procedural safeguards includes proportionality, centulia. We say there's authority directly on point, which is binding on this court. And if you turn to paragraph 7 of the Secretary of State's skeleton argument, page 55, you can see what drives the Secretary of State's analysis is this distinction between substance and procedure. And we say the distinction between substance and procedure that's being drawn is not an appropriate interpretive tool. It's not an appropriate interpretive tool for two reasons. Firstly, because the distinction between 20.1 and 20.2 is not between substance and procedure. The distinction between 20.1 and 20.2 is a distinction between grounds that are found in the CRD and grounds that the national legislature may wish to rely upon. That's the distinction between them, and it's the only distinction between them.
So how would you define the difference between substance, as Ms. Smythe uses it, and grounds, as you invite us to adopt?
Because grounds are the reasons for deportation, but they may be subject to limits. And we submit proportionality is such a limit. But if you take the step that grounds equals substance, and then you look at proportionality, well, that looks substantive, that does some work in restricting what can be done, therefore you can't apply it. But the step between saying grounds to substance is not one that finds a basis in the terms of Article 20 of the agreement. You
comes back to the point that on your interpretation, procedure includes proportionality.
Yes.
Whereas under this may be a simplification, Ms. Smythe's case, that comes under substance.
Yeah. Well, first, so I said there's two issues here. First is to have the category of substance at all. Because the category of substance is just a construct that's been applied, which isn't part of the words of the Withdrawal Agreement. It's not there. It's an inference that's being drawn about what Article 20 is getting at. The second problem is that the Secretary of State is applying a common law notion of procedure and what that means, and is therefore saying, well, obviously proportionality is not included in what a procedural protection is. But that is a second fallacy, because as we've seen from Centulia, the Court of Justice itself says that Article 15, headed procedural safeguards, Article 31, headed procedural safeguards, includes the principle of proportionality under 31.3. So what the Secretary of State's analysis hinges on imposing a sort of common law framework, distinction between procedure and substance, where both the concepts of procedure and the concept of substance are being imbued with a very domestic meaning. And that's not the appropriate approach to take to analysing the Withdrawal Agreement.
Well, I mean, one point is it's Vienna Convention international interpretation, not domestic interpretation.
Yeah.
Even if you don't go so far as to say you've got to look at EU law.
My lady, yes.
But in any event, Article 4 of the Withdrawal Agreement sets out a whole load of interpretive principles which the parties have agreed should apply to the interpretation of the Withdrawal Agreement.
Yes. So that's my point. Procedural
Yeah.
safeguards have to be interpreted in accordance with EU law, because that's where the concept has come from. And you have a definitive, authoritative pronouncement on what they mean, and it supports my case.
You mean Chinchilla?
Chinchilla. Can we then just, for a few minutes, look at the upper tribunal's reasoning? In a sense, the reasoning.
Well, that clock's slightly slow. How are you doing generally?
Yes, I'm not doing too badly. I've made most of my submissions on ground 2, which is obviously the main.
Okay. Well,
main ground.
have you got a couple of points you can make quickly on?
Yes.
On the upper tribunal's decision.
So it's at tab 14. Para 61.
Page 100.
Sorry, page 154.
54.
Yes. 154. So the beginning of the analysis is at 61 first sentence. And the upper tribunal talks about there being 2 defined classes of individual. One that retains their rights after completion day and one that doesn't. This, I think, gets matters off to the wrong start, because there aren't 2 classes of people, there's 1 class of person, and there just may be different reasons why you might want to restrict their rights. And the question is whether you're restricting their rights on the basis of something that's happened after completion day, but it's the same class of people. The reason they're thinking of it this way is because they're thinking in terms of prisoners, and they're thinking we've got the HMG prison estate. Some of those people have their convictions relating to things that happened before completion day, and some have them afterwards. And so that frames their thinking. But of course, Article 20 is not necessarily anything to do with prison. So. Then, if you look at 63. There is a bright line distinction to be drawn between the regimes that apply. In relation to the latter, the intention of the withdrawal agreement is clear that the substantive provisions of EU law, including the application of EU law, cease to be applicable. Well, there's right that obviously there's a distinction between 20.1 and 20.2, but there's no basis in my submission for saying that it is clear that substantive protections cease to be applicable, including proportionality. The reasons I've given, that is, in fact, the opposite of what EU law tells you. And the court is adopting there this notion of distinction between substance and procedure, which, as I've said, is essentially adopting an unduly domestic law framework. 65 and 66. They start by saying that Article 20 is clear and unambiguous, and at the end of paragraph 66, the sentence beginning at the bottom of page 155, I'll just make this point and then I'll pause. Applying the approach to construction which we said above, we accept the submissions that Article 21 must be read together with and alongside 20.1, 20.2, and not as importing substantive EU rights into in respect of those committing conduct, rendering them liable to be considered for deportation. These are commonly understood to be the rights to be notified of the decision and how to appeal it, the right of an effective remedy, and the right to a fair hearing. That common understanding, I mean, where's that common understanding coming from? It seems to be a common law concept. It's not linked properly at all to the CRD, which is what we're concerned with.
Right,
My Lord,
I
I'll
think
stop
that's a good point to stop. I know it's halfway through your submissions on the upper tribunal. remind us where Chinchilla, what tab number is Chinchilla?
56.
56.
Lunchtime reading.
Lunchtime. Thank you. I think you're more or less on track, aren't you?
Yes, that's fine.
Thank you very much. We'll resume at 2 o'clock.